everyone. Thank you for joining us for another Clarion podcast. I am joined today by Professor Dominic Regan. We are very excited to have him here today, and we are going to be talking about hourly rates. So firstly, Dominic, obviously this report was published on the 30th of July. What do you think of it?
Well, I suppose the first thing to say is how massively overdue it is. The guideline hourly rates, I think people appreciate, were last revised in 2010. In 2014, there was an attempt to revise them, but Lord Justice Dyson, who's then the master of the rolls, wasn't happy with the work, with the figures, with the underlying statistics, and he said no. And so 7 years on, we drift on, and now suddenly we've got new figures. So I suppose the real question, because I mean you're the cost expert, is you've looked at the numbers. Is it a big increase?
It's tricky because obviously we were very lucky on the Court of Protection side of things to have the increase with PLK, and whether it was naivety or I'm not sure, I thought that they'd stick, and they were obviously a 20% uplift, which was quite calculated, it was consistent throughout the different bandings wherever you were geographically. Whereas with these proposed guideline hourly rates, they differ massively dependent on where you are in the country without any real rhyme or reason. Particularly, I think National Band 1 lose out. They don't really get any great increase. National 2 seem to do very well out of it. There's no real difference now between National Band 1 and National Band 2, and all London bands seem to have done quite well out of it as well. So it varies so greatly. And I think the big problem that we're going to see from a Court of Protection side of things is Grade D massively lose out with these, and they don't really get a pay rise at all, and they're the ones who are going to be doing most of the Grade D work.
Sure. And in fact, that's bizarre, isn't it? Because then you get an incentive to say, well, we won't give it to a Grade D because the money's so rubbish. So you then use somebody more expensive. And of course, then the costs go up and people complain about the cost inflation, costs increasing. So in a way, you'd almost want to, I would have thought, incentivize people to use lower grade fee earners because it's more economic.
Exactly, and incentivize people to delegate, whereas I think this will do the opposite. But I don't.
That's a great point. No, well spotted.
I don't know what you think of the increase. Do you think people will be happy with it? Do you think it's reflective of 10 years?
Well, I suppose number one is that a number of judges, and like in the commercial court particularly, have said that the current rates are a joke. They're way out of touch. I do stuff for firms in the city, who charge their own client, not inter partes, of course, but firms who charge their client £950 an hour for a Grade A fee earner. So there's still a massive divide between inter partes costs. And I suppose the other point, which I genuinely want to ask you, I don't make this stuff up, is, how easy is it? Because they are guideline rates. We're always told they're guidelines, they are not fixed. So it's not like car tax, where if your car tax is 500 quid, it's 500 quid. But a guideline that's 500, a judge might say, well, actually, you know what, this case is special, we can increase it. So how easy is it, perhaps in your court of protection work, how easy is it to escape the guidelines?
Not easy, which I think people are going to find really frustrating, even though it says that it's a guideline and, cost officers and cost judges should use these rates as a starting point. With COP, we always find that they almost glue to them. They are so difficult to depart from. And I think in civil and commercial work, that's not really the case, is it? They do recognise that it's a starting point.
Sure.
But with COP, that's just not the case at all. I can see a lot of firms getting really frustrated by this because we've already had lots of retainer updates and lots of paperwork updates to reflect the PLK rates. And then as and when these are approved, we're going to have to do all that paperwork again, revise them again, some rates going up, some rates going down. And is it going to be that, I don't know, that the cost officers and cost judges will allow it from the date that it's approved? Will they expect paperwork immediately? I don't know. What do you think?
I don't. Well, I mean, one argument that has just floated into my head, if I was a paying party, I'd say, well, look, these rates have just been the ink is still wet on the rules. But these have just been looked at. Therefore, these are bang up to date. Why should you be departing from them? You can see. I can see that. I mean, there is always an argument about exceptional circumstances. But there's a bit of a suggestion there that well, here we are. It's not as if they're stale. It's not as if you can say, well, as you could today, they're a decade old. They are as fresh as a daisy. Therefore, why don't we just adhere to them? And that way we've got certainty as well. So I can see problems there. And the other point I really wanted to make, and it's not my point, but the senior cost judge in a chat last December, so not in a judgment, but he made a point of massive importance, namely that the new figures aren't retrospective, because there are people saying, oh, well, the new rules, we can, what about 2017, 18, 19? He's saying we are coming up with one set of figures. And he said it was hard enough to get agreement on those. We weren't ever going to try and rewrite history and come up with figures for the last 11 years. So what again, something to watch out for is whether we will, and I think we will, whether we'll see people saying, well, if this is the new 21 rate, and I think we might have them in place in October, and we'll see, but I think by the end of the year. Well, how about what we do? We look at the new figures, and for work done 2 years ago, we knock off a little bit, but it'll still be a lot higher than the old rate. So there's going to be a really interesting tussle, I think, about how one can try and use the new figures to drag up earlier work, the value of earlier work. And that's, I think, a major untested point of principle. So
So retrospective claims, people
people, and because the dichotomy, the gulf between all, as you say, where the rates have rocketed, you can see why people will want to say, well, if these new enhanced rates are good, then it's a travesty that you're trying to foist upon us rates that are massively lower, set 11 years ago, for work that we did 2 years ago.
Yeah.
Big stuff, big stuff, Stephanie.
Yeah. Do you envisage any other issues with these new rates?
Well, I suppose the one, my final thought on this, and again, there's been a lot of chatter, of course, is that whilst all this was going on, we've had this revolution in the way that people work, and of course the rates have been set on the assumption of where, as you mentioned quite rightly in your opening, about geographical location. But if somebody's got an office in London, but the staff work 4 days a week in Wales, or the Millionaire's Playground of Grimsby or somewhere, then aren't the figures going to be a bit? Aren't people going to say, well, hold on a bit, this is a fallacy. This doesn't make sense, because you're charging me for, on the basis that this work is central London work, and, the rent's, £500 a square metre or something, when in fact it's all being done from the shed at the bottom of your garden. So that is something, I mean, that is not going to happen straight away, but that is something that is not going to go away. That's another, I think, something I anticipate.
Yeah, I couldn't agree more. Do you think, you mentioned then, or a minute ago, sorry, about these potentially coming into play in October. Do you think they will be approved that soon, or do you think we'll be waiting a while?
It's a movable feast, isn't it? I mean, they've been accepted, it seems, by, now rule change ordinarily occurs twice a year, namely April and October, so 6 months apart, a rolling 6-month pattern. If it's not October, then it seems to me that the likelihood it will then be April of next year. But we were waiting for this a long time. The proposals emerged, if you think about it, round about Christmas of 2020. So, and in fact, interestingly, the final paper that you refer to, even though it appeared at the end of July on the cover, it said April. So, I mean, there was some lag in there too. So I think that it could, pretty like it's going to be, I would say, October, or failing that, April 2022. But I think it's now a done deal. It's a certainty. Yeah.
No, that makes complete sense. And final question for you. Do you think that we will now see more regular reviews of hourly rates, or do you think we'll be waiting another 10 years for another?
Oh, well, I think the answer is probably somewhere in between. Regular reviews. I mean, when I was doing stuff with Sir Rupert Jackson, his idea is that rates might be reviewed every 3 years. Yeah, not that we've had fixed costs brought in yet. Waiting 10 years, I mean, was a travesty. And in fact, as I mentioned earlier, they did 4 years on, tried to review, but failed. So my, again, just instinct, I don't know. But, you know, we've got the figures. Let's see where we go. But they're not going to want to do this exercise all over again. It was murderous for them. I know that from people who were involved in it. So maybe 3-4 years down the line. But you know what? Accept what we get and live with it. Yeah.
Yeah, and hopefully we're not waiting another 10 years.
No, God, no.
Yeah. Right, well, thank you very much, Dominic. It was wonderful to have you.
Well, you too, Stephanie. Very good.